NTA Blog. Protect your employee retention credit claim. Use IRS's new streamlined process to request an extension. If your employee retention credit, or ERC claim has been disallowed, there's something critical you need to know. A strict 2-year deadline is already running, and it does not pause while your case is under IRS or appeals review. That means you could be working with the IRS in good faith, waiting for a decision, and still lose your right to a refund or even the ability to go to court. Once that deadline expires, it's final. The IRS can't issue your refund, even if your claim is valid, and you lose your right to challenge the decision. This is a serious risk, and many taxpayers aren't aware of it. Here's why it matters. The IRS administrative process can take a long time, often close to a year or more. In some ERC cases, the IRS issued disallowance notices before fully reviewing the claim, then sent cases back for additional review while the clock kept ticking. That creates a situation where delays, not the merits of the claim, can determine the outcome. There is some good news. The IRS has introduced a new streamlined process to help certain taxpayers protect their rights. If you protested an ERC disallowance and have 6 months or less left on your 2-year deadline, the IRS will send you a reminder notice. This notice explains how to request more time by submitting Form 907, Agreement to extend the time to bring suit, which extends the deadline to file a lawsuit or receive your refund. You can complete the form, submit it electronically, and if approved, the IRS will sign it and return a copy to you, giving you additional time, typically up to 2 more years. But this process is limited. It only applies to ERC claims, and only to taxpayers who have already responded to a disallowance. That means many other taxpayers with disallowed claims don't get the same protection. So what should you do? First, track your 2-year deadline carefully. It's not listed on IRS notices. Second, act quickly if you receive a reminder notice. And third, consider submitting Form 907 proactively if you're eligible, even if you haven't received a notice. This issue goes to the heart of taxpayer rights: the right to be informed, the right to challenge the IRS's position, and the right to a fair and just tax system. The IRS's new process is a step in the right direction, but until broader protections are in place, taxpayers must stay vigilant. Because when the clock runs out, the opportunity for a refund is gone.
The audio version of the NTA blog is created using AI for conciseness and a computer-generated voice. Although reviewed by a human, inconsistencies in context, pronunciation, and tone may occur. The views expressed in this blog are solely those of the National Taxpayer Advocate. The National Taxpayer Advocate presents an independent taxpayer perspective that does not necessarily reflect the position of the IRS, the Treasury Department, or the Office of Management and Budget. NTA blog posts are generally not updated after publication. Posts are accurate as of the original publication date.